Welcome to Court Helicopter Explainer, where we have just been recalled, as I said, out of the experiences of what is happening and the surrounding behind the late Justice Majanja's burial, and about the will, and about that money that was supposed to be dispensed to the beneficiaries not being done. We're also looking at the will of Raila Odinga Amolo. He said he must be buried within 72 hours. What is the legal basis of a will? The law of succession, chapter 160 of the laws of succession say the properties you own when you are alive, they will not be buried with you. Nobody has ever been buried with the properties. They will move to your people through succession. Either through succession that, if there's no will, it's called intestate succession, where people must fight for the court to decide. But now, as we are saying, we are dealing with the law of testate, where there's a will. There was a will in Baba's case that he must be buried within 72 hours. There was a will for Majanja that he must be cremated immediately. And all those wills were respected. But we have seen in all media houses a dramatic twist that there is now a dispute about the will of Majanja, not about his burial, but about who is supposed to inherit, who is supposed to have that. We promised from episode 1 that in episode 2 we will tell you how do you write a will, and that will cannot be contested in a court of law. 1, the requirements for a valid will in Kenya. Number 1 is the legal capacity of the one doing the will. That person who is going to die, there are requirements for that person. The first one is that he must or she must be at least 18 years and above. A will cannot be written by a minor who is below 18 years. 2, he or she must be of sound mind and memory. Mark my words. Whoever writes a will must be somebody with a sound mind. You are not mad. You have no mental problems. Remember, we have so many people suffering from mental illness. They cannot write a will because if they are mentally challenged, they can't do that. 3, the question about memory. In a will, you must memorize your properties. You must memorize your children. So if you don't know the children you are giving the property, you are saying, I, Danstan Omari, I'm giving Kenyan, my eldest son, when you don't even have a son, you don't even have one child. That memory will be questioned. If there is any inadequacies and anything that shows at the time you are writing the will, your memory was affected, that will not stand today. And we are going to look at the grounds why wills are made invalid. 3, he or she must act without any undue influence, freely entering a will. If somebody has been forced, if somebody has been influenced, if somebody has been threatened, if somebody fears something, if somebody fears certain repercussions, then writes a will. That will be a ground for nullifying that will. So the person who writes a will must be writing that will in her or his own voluntary behavior. There is no influence and there is no fraud. He has not been cheated. She has not been cheated. That what you are signing here is a document for you to be released from hospital. When actually that person was dying in a hospital, he was told, you sign here, a release cheat from the hospital. Yet it was a will saying the properties now are given this one wife or two of his children. Any fraud, that person will not be there. Lastly, he must understand, or she must understand, the nature and the consequences of creating the will. Is this person in full capacity of his or her faculties? Does she or he know the consequences of writing a will? That must be tested. So when you walk to an advocate's office, when you walk to Danstan Omari and Associates as you sit up here, those are the questions that we'll be asking you. Are you a minor? Get out. Are you of unsound mind? Walk out. We'll not do your will. Third, are you influenced? Are you being brought into my office at gunpoint to write a will? I will not allow you to do that. 4, do you understand what you have come to tell me? Do you understand what a will is? Those are the 4 conditions that are required for one to be allowed to start the process of registration. Step 2, we've done step 1. Now the will, execution of the will. Step 2 is execution of the will. It must be in writing. That will must be reduced into writing. You walk to me, you tell me your story, you tell me who you are, you tell me the properties you have, the lawyer must reduce it in writing. If it is not before a lawyer, you who is writing that will, you must write it in writing. Wills must be written. We'll deal with other wills called oral shortly. We are dealing with a written will. 2, the person who walks in and wants to write a will must sign in the presence. Mark my words. The one writing the will must sign in the presence of 2 witnesses. There must be 2 witnesses. In the presence. And 2, in the presence of the one drafting, the lawyer drafting that will. You can't draft a will in River Road or in the village that you bring to an advocate to sign. You can't draft a will and you go and take it to the witnesses to sign. As you are signing, as your father is signing, as your mother is signing, it must be in the presence of the witnesses. They only see the signature being signed. The witnesses don't need to know what the distribution is. They must see a signature of the person who is putting that. Third, the people who are witnesses must be competent to be witnesses. What does that mean? They must, 1, be younger than the person doing the will. 2, they must not be the people who are going to benefit from that will. So if you are a child who has been given a property in Kileleshwa, you cannot witness your father signing that. If you are a wife, and this especially goes to second wives, the Gashungwas, the ladies who come after the first wife have made an inroad inside. They are normally present when the wazis are dying. If you sign as a witness and you are given any property in that will will be declared illegal. So any witness cannot be a beneficiary. Get it very clearly. If you are a beneficiary and you are a witness, that will is null and void. 3, what is the qualification of you to be a witness. One, you must be above 18 years. A minor cannot be a witness. Two, you must be of sound mind for you to be a witness. Three, you are not a beneficiary at all. And lastly, both of you must be, and I repeat, both of you must be present when the signature of the tester, the person doing the will, is doing. So if one is not present, but one is present, that will is null and void. Both of you must be before an advocate. You see the will being signed. That is step 3. Step 4, the formal format and the content. In the will, the following must come out very clearly. 1, all the details of the person doing the will. I don't want to use the tester because it's called in legal terms a tester. I'm not addressing lawyers. The lawyers know that. I'm addressing the people who are not lawyers. That person doing the will is what the law calls a tester. The details of that person must be captured. 1, his or her full names, his or her telephone number, his or her ID number, his or her address, his or her email if she has, and his or her address where the residence is. Number 2, if that person had a will previously written, that person that must revoke the previous wills. The law is you can't have 2 wills. So the new will must state that this one revokes the previous will that was there. You cannot have 2 valid wills. 3, the beneficiaries, those who are supposed to benefit, must be clearly be identified. Equally, their names, their telephone numbers, their ID numbers, their box numbers, and their email numbers. That is why you said the one doing the will must have full memory. If he can't or she can't remember her children, he can't remember his wife, she can't remember the details about her husband, that will then will be challenged that he or she didn't have full capacity. Then we have the properties. The properties of the one being writing the will must be clearly be identified. Proper description of the property. Don't say, ile shamba iko karibu na mto nimeachia Mary. The car I drive, I give it to Vivian. My specs, this one, unless identified, then I say the specs go there. Or the water Wakili Omari normally drinks goes to Lewis. It must be very clear. What do you mean? If it is a car, the car must be identified by the registration number, full registration number, the make of the car, and the color of the car. If it is land, the land reference number of that land must be identified. Where it is situated, it must be identified. The acreage, the size of that land must be identified. If it is money, the money must be identified, which bank they are, account number, and the amount in that account number. So if you are giving somebody a property in a will that is not known, that is not described, that will be a ground to challenge that issue. Then 4, who will be the executor? Who will administer that property? who will execute your instructions. A will are instructions. You have told people, when I die, this vehicle goes to so and so. I appoint Cyrus Kimanga to do that. You must appoint people to do that. They are called executors. Then you give the date of execution. When did you write this will? It must be very clear. The lawyers will tell you, dated on the 14th day of January 2020 at Nairobi. A will must have a date when it was written. If it has no date, that will is null and void. Lastly, on that issue, it will also be attestation clauses. When we talk about attestation clauses, it is about, it was drawn by Danstan Omari and Associates. And the person who is swearing, they call them the deponent. If you look here, as court helicopter is showing you, you are being shown the will as it is rolling. The date, it will be there, dated. It will show you drawn by this, signed by so and so. The person is called a deponent. Before a commission of oath, it is there. You have appeared before Danstan Omari, you have appeared before Damaris, you have appeared before Calvin, you have appeared before Lydia. They will be there. Your signature will be there. That is the clause of attestation. Then the witnesses also must be included. The witnesses must sign in the presence of a commission of oath. And lastly, the lawyer who drafted this must give down there that these people, I confirm they appeared before me on this date, at this time, in my chambers, and I drafted this document and they signed when I'm there. That is the certificate the lawyer must do. If the will doesn't have those things, my friend, you will cry. Let us go on the alternatives. If step 5, you want to have some alternatives, you have given Kelvin this land. If you die together with him, he will not be there to take that land. So some wills, you have got to give alternatives. For example, if the beneficiary dies, as I've said, hypothetically, the one who was supposed to inherit dies. A good will should include, if he dies, his wife or children automatically take that position. So you must give an alternative. Don't leave it like that. An helicopter can come and crash. You and all your beneficiaries die. But there is one girl at Kenya High remaining alive. That alternative now comes in. So that that will does not become moot. It doesn't become a useless thing. 2, you have children. In the will, then you must appoint what are called guardians. Because these kids cannot inherit the property. So if you die while your children are below 18, you must put in the will the guardians to take over. They are called testamentary guardians. They'll take over these properties not as their own, but as trustees for the minors until they grow. And this is where many children are suffering on the streets, because the guardians took over this property when the children were young, They turned into the properties to be theirs. The children, when they grow and they are 18, they try to ask, they say, we paid fees for you. This property took up. So it is a criminal if a trustee dispossesses the beneficiary their entitlement. 3, do you want to say how you'll be buried? The provision for your last ceremony. Here is where you give directions about burial. You don't want a person called Cyrus to attend your funeral, because every other time he has a camera, he's recording you. You don't want somebody called Damaris to appear in your funeral. You want to be buried in a particular suit. You want to be buried in a particular kofia. You are a political leader. You want to be buried with a particular political party cloth. You are a lawyer. You're saying, if I'm killed by anybody, bury me with a torch. These are instructions that you put there. So the manner in which you want to be buried, and that is why Baba gave clear instructions that he must be buried within 72 hours. That is why Justice Majanja gave it very clearly that he will be cremated. What do you foresee? How do you want to be buried? And this is what I'm saying. You are a poor person. You have nothing. And you are saying, if I die, I must be brought to Lee funeral home. Your home is in Garissa, your home is in Mombasa, your home is in Kwale, your home is in Nyamira, your home is in Kakamega. Your family can't even afford to buy a coffin worth 5,000 shillings. But in your will, you said you must be brought by chopper to Lee funeral home. Then you are brought with those type of limousines car that look like butterflies carrying you with your coffin there. And you must be flown back by chopper to Mombasa Airport, to Wilson, from Wilson Airport. Are your requirements, are your instructions practical on questions of burial? Have you said that during burial, attendance of people must be given each 5,000 shillings to attend your burial, yet you don't have any money? So here, the practicability is what can be taken to court to be challenged, that it cannot work, and the court will declare that burial clause illegal and practical, and because of your station in life, you cannot be accorded. You can't order Omari to make sure that Omari meets all those bills. You are not my son. But even if you are my son, you can't tell me that I must spend 10 million shillings for your burial. So the burial clauses are not absolute. It goes on to say, the debts and taxes, you must include how your taxes, your madeni, will be dealt with. For example, when you die, you have had people in a funeral say, who does he owe? Is she owing anybody? Come. The family will deal with those issues. So according to you, indicate how your taxes and bills will be done. And lastly, consider the properties mentioned on how you will be taken. Lastly, let us look at types of wills. We have the formal written will. We have already explained that. Formal written will, we don't need to it there. We have the second will called holographic will. This is one written by the person himself. He has no witnesses, he does anything. He just or she decides to write. This can be contested heavily because there are no witnesses, no lawyer. So So when you feel that you want to die, just call a lawyer to do that will for you. But if you write, it can be challenged in court. It is called holographic. Third, the oral will. This is when somebody is terminally ill. Normally they call their kids, their beneficiaries, to a bed and they want to give them an oral will. Conditions that must be met in an oral will is that you must die within 3 months. The person writing that will, who gives the will, must die within 3 months. If the will lives more than you for 3 months, that one is not a will. That is the most critical issue of a will. So that people fear a lot. People fear a lot. You get sick. Then you say, me, I'm dying. Me, I'm dying. Come, I tell you guys. Me, my glass of water, you can give it to Damaris. 4 months, you are still alive. That will is dead. So if you want to a will, purpose to die within 3 months. But if you don't, there is no will about oral wills. Then we have the privileged will. This is a will for the people in KDF. Those people in combat zones. Whatever they say, whatever they write, it's a privileged will because their life is on an imminent danger. Then we have 5 joint wills. Do you know we can have joint wills? Here, parties form a joint will, not one person. For example, there are people who own properties together. They can do a joint will. And the conditions for one to appoint to have a joint will, it is normally a foreign concept in Wazungu country. In Kenya here, every property is owned individually. But some regions, they own those properties jointly. Then we have also mutual wills. Normally, this is 2 spouses doing a will together, husband and wife. These guys have octogenarians. They are 95 years old. They don't know when they are dying. So they do the will jointly and sign their documents jointly. But that is very risky because if one spouse wants to dispossess this, then that message is known to. The reason for an individual will is because you don't want war before you die. Once people know in advance, they will not get anything. They can kill the brothers or the sisters who are going to do that. Lastly, in the will, you must have an inventory of the properties that you want to put in a will. If you don't know them, you are going to have a problem. What have we learned from this episode? Draft a will without dispute. And we have given you how to draft a proper will. My advice, do the will because you don't know when your day will come. Wakili, Danstan Omari, always bringing it to you because we looked at the Constitution. Why did we do 25 episodes of the Constitution, which you still can get in Court Helicopter explainers over December holiday and January holiday? Is because Raila Odinga and Kibaki are the ones who read the Constitution. They are dead. We had to do it for you. Today, why are we doing the explainer on the wills? Majanja judge has died. A dispute has arisen. Baba has died. Is there a likelihood of a dispute? We always bring it to you questions that are live of human interest. Wakili Danstan Omari from Court Helicopter wishing you a happy new year.